Good morning, everyone. We're rolling, we're live and we're on. Welcome, everyone. Good morning. Hello, and thank you for joining us today, whether you're here in person or online in the worldwide interweb. And thanks for joining us at Aitken Partners Breakfast, Business Law Breakfast. Today's topic is debt recovery, key insights for professionals. My name is Mike Chenoweth, and I'm a principal lawyer in the litigation team here at Aitken Partners. Today we'll be discussing some insights and practical strategies to optimise your debt recovery processes that will enable you to enhance your debt collection efforts. We'll be talking about best practices, how you can best protect yourself before things go wrong and also when they do go wrong. And examine some real world examples, hear a few horror stories because we're lawyers and we like to know about when things go wrong, and leave with some top tips to take away and to think about. We thought we'd do things a little bit differently today, so rather than propping someone up in front of a lectern, which is actually me, but I'm going to be very small here, we thought we'd have a bit of an informal discussion here rather than having you listen to someone speak to slides and whatnot's a bit too early in the morning and coffee's probably not kicked in just yet. So we have three wonderful panellists for you today as we run through the many intricacies of debt collection. So in the spirit of this sort of less formal forum, while we'll of course take some questions at the end, we also invite you to ask some questions as we go along. So if you've got any questions, feel free to pop your hand up, or on the interweb thing, whatever you do in the chat function, there's something there. I'm not sure what that is, but if you're dialed online, you know how to do it. So now, it's my pleasure to introduce our panellists. Firstly, we have Caroline Skioch. Caroline joined us at Aitken Partners earlier this year as a special counsel in our litigation team. Caroline has extensive general litigation experience, which includes working for local and state governments and other statutory bodies, individuals and small and medium businesses. Caroline's practice includes complex litigation and commercial matters, and most relevant today, large-scale debt recovery. Next up, we have Rod Lindquist, who also joined us earlier this year as a consultant. Rod has over 4 decades of legal practitioner experience across an array of fields. Rod works as a general commercial lawyer in both our property and commercial law and litigation teams, and really importantly, he's actively engaged with mentoring young lawyers at our firm. Last but certainly not least, we have Isaac Choi, who was recently promoted to associate. Yay, Isaac! Isaac is a commercial litigation, employment law and debt recovery lawyer, and is also a member of our firm's Asia advisory team. So please, everyone, welcome our panelists. As I said, we're here for debt recovery. Now, we sort of is what the name suggests, which is recovering debts, and we know that generally speaking, debt recovery involves heading to court and whatnot, and we'll get to some of the intricacies later on. But Rod, I was just wondering if you could say, whilst we know that debt recovery ends in the courts, where does it actually start, in your view?
Well, in my case, it started at the beginning, because when I first started practicing as an article clerk, I worked for a sole practitioner who had a debt collection practice. He happened to be the laziest lawyer in the world, so I had to learn everything from day one. And so debt collection I got straight into. And I discovered quickly that there are some basic principles that you need to sort of follow when you're running debt. The first thing is know your own details. It's amazing how often we'll get instructions from a client and they'll give the wrong ABN, for example, because they've got the wrong ABN on their stationery or on their letterhead. And one of the problems in businesses is people don't interrogate their own information. And it's something you should do probably on an annual basis just to make sure things are correct and right as such. That's the first thing. Secondly, you need to have a credit application. And again, you're best to get advice externally on the nature of that and what should be placed in that application. And when you receive it from your client, you then need to carefully interrogate what they've actually written there and just double check and make sure it's factually correct. That's the first starting point. Credit application should also have a director's guarantee attached to it as safety, because in the main you'll be dealing with corporate entities on the other side, and as we well know that once they collapse, the individuals behind it tend to disappear and won't make payment. So personal guarantees are very important. You need to have good terms and conditions, and that's become very important in the current environment of unfair contract terms. I'm not sure whether you're all familiar with that, but that legislation first came in about 5 years ago, and last year it was broadened such that unfair contract terms applies to any business with a turnover of up to 10 million and up to 100 employees. And that covers probably about 95% of the businesses that you'd be dealing with. So you need to be very wary of what is stated in those terms. You also need to consider a privacy policy as an adjunct to your credit application, because you are collecting personal information and you've got obligations under the Australian privacy law. So again, when we do a package of those documents, we put them all together and usually do it for a reasonable fixed fee. The other thing you need to have is a collection policy. You need to actually work out what steps you're going to take in terms of your debt recovery. And you can decide whether you're going to do demand letters or whether you're going to do telephone calls and things like that. Now, bearing in mind in the current day and age of Australia Post, demand letters are very slow. So it's probably a good idea in your terms and conditions to have your client, one, provide an email address, and two, consent to service of any documents and notices by way of email, which makes life a lot easier for your solicitors acting for you. Industry quirks. Some organisations, because of their professional association, are required to do certain things before they collect. For example, legal practices, we have to give people full details of our fees before we can actually go ahead and sue. If you're in the gas and electricity type consumer markets, you have to take certain steps before you can actually sue and so forth. So just make sure your organisation that you look at your own rules and make sure that you've complied with those before you head off to court. Otherwise, you might find that you get struck out for that very reason. That's about enough for me at the moment, I think.
Well, you don't get away with it that easy.
Congrats.
I'll be asking the questions here. You mentioned terms and conditions and some of the relevant parts in it. A lot of us here will be familiar with the word caveat, and that comes up a lot in terms of protecting people's interests and whatnot. How do we go about, well, firstly, what is a caveat? How do we go about lodging it and what needs to be done?
Okay, well, a caveat is a document that's lodged at the Land Titles Office in relation to a particular title or titles, which prohibits any dealing with that land unless the caveator is actually dealt with properly. To lodge a caveat, you have to have an agreement with the other party, which allows you to actually take an interest in land. It's got to be specific. If you don't have that agreement, you can't lodge a caveat. But it becomes more complicated as well. In terms and conditions of trade, historically people have put in charging clauses, which in effect gives them the right to actually place a caveat over a title. But due to the unfair contract terms and a federal court decision which has come out, there is an assertion that if you have adequate protection through the PPSR, then it's an unfair term to actually request a caveat over a title as such. And if you attempt to do that, it could be struck out by a court. So you've got to be wary of that. The way around that is to put in a trigger that clause only applies in the case of an insolvency event as such. So you've got to be wary. The other thing about caveats too is that practitioners have to be of the opinion that their client can validly lodge a caveat. Good practitioners do think about that. There are plenty around that don't. That's something that we have to bear in mind, and if we allow clients to put caveats on willy-nilly, we have ethical issues we've got to face up to.
And the party that ultimately lodges the caveat, or the business in this case, they can actually be liable for costs or damages if a caveat's been placed improperly, hasn't it?
Indeed, and they can be substantial. You know, if you stop a sale, for example, it could be tens of thousands of dollars.
You touched on before getting the client's details right, and I'm sure you've seen it before and I've seen it before. We'll get something that pops up where we'll say the customer or the client is such and such trust, the John Smith Trust. But as you probably all know, trusts aren't a thing, they're a legal fiction almost. They ultimately act through the corporate trustee. And unfortunately, as distinct from companies and whatnot, there is no register of trusts. You can register a trust name or an ABN. So that's also a key detail. I think that's very important to get the client right, because if you are trying to sue the trust, you need to actually sue the trustee. And we have a question from online.
If you don't have PPSR registered, can you use caveat as your way to collect your debt?
No.
Would you like to elaborate?
Well, that's the answer. Yeah. Look, PPSR relates to personal property as such. The nexus with the caveat is a charging ability, some sort of security document as such, which applies to land. It's got to be specifically applied to land. So, to cut back to the chase, unless you've got an agreement with your client that allows you to actually attach to land, you can't do it. Yes?
Look, I just had a client who himself put a caveat on a property. Who is the authority that says, oh, you've met this criteria, you are now allowed to put a caveat on a particular... Is that your lawyer that says that, the titles office? Or what is the authority that stops someone from coming in off the street and slapping a caveat on your property?
Can we just repeat the question for online first?
Sure. Oh, okay.
You can repeat the question.
There is a difficulty in that most people would use a conveyancer or a solicitor to lodge a caveat. However, an individual can go to the Land Titles Office and put on a caveat on their own. Now, if they do that, the Registrar General, generally speaking, would interrogate that person as to what they're up to, but they may not, and on it goes. In that case, you then need to challenge the caveat through the appropriate channels. You file a document, or sorry, you send a document to the caveator, which requires them to issue proceedings to enforce it within a certain period of time. If they don't, then the caveat lapses. Thank you.
A couple more questions before I'll let you go, Rod. Jurisdiction clauses in credit applications, why are they important?
Well, if you issue in the wrong court, you might get struck out for want of jurisdiction. This can occur when you've got transactions between two different states, and you might have a credit application that you've drafted in Victoria, you've got some business you're doing in New South Wales, and if you don't capture the jurisdiction in that document, you might find you have to issue in New South Wales rather than Victoria, which is quite inconvenient.
And lastly, Evidence Act's implications there in terms of service of matters by post and whatnot.
Yeah, look, under the Evidence Acts throughout Australia now, deemed service of a letter is taken to be 9 business days. Right, so that's effectively 2.5 weeks. So if you're sending if you've got a demand at law that you have to send, and you've got that amount of time to wait, it's just too long. So hence you can overcome that by having the client agree in the credit terms to be served by email.
Any horror stories before we move on, because that's what we're really interested in?
I'll give you a reverse horror story. I had a client where they were dealing with someone for many years consistently, as though everything was hunky-dory. And then all of a sudden they went off the radar, and they followed up, and the company had been deregistered. And there was a substantial debt, it was about $30,000. And I said, well, what do we do? I said, we've got to make a commercial decision here. And if you've had sort of consistent dealings with this person and they paid regularly before, there must be some oddity as to why this has occurred. So it's probably worth investing in some proceedings. And in that case, a deregistered company doesn't exist at law. So what you need to do is you apply to the court to reinstate the company and wind it up in a simultaneous action. The first one I did in court was a nightmare because the bloody judge didn't understand what was going on and said, why haven't you served a creditor statutory demand? So, well, how can you serve a demand on a non-existent entity? Well, that's what you have to do. I said, well, it's impossible. You can't do it. Anyway, eventually he was persuaded to do that, and we wound it up. And the day after the wind-up, we got a phone call from the former director. He said, oh, God, I'm sorry about this. He said, my wife died a year ago, and I haven't been able to manage my affairs. Just let everything go. I'll pay you tomorrow. So that's a reverse horror story.
Thanks, Rod. Caroline, you're next. So we've heard sort of where it all starts. It's gone wrong. What's the first sort of step in the debt recovery process?
Thanks, Mike. The first step really is your letter demand process, so your initial contact with the debtor. That might be by telephone call or by letter, and as Rod points out, best to get that to the attention of the debtor sooner rather than later. Don't rely on Australian Post. If you can email it, email it. My sort of top tip or hot tip about that is, if you can ring up the debtor and have a conversation with them at first instance, do so. Picking up the phone is quite often the easiest, most effective way of resolving a dispute in the early stages. At least it gives the debtor the opportunity to tell you if there's a genuine dispute about the debt, or if they've got anything they want to say about their position, about ability to repay or anything like that. It opens up that line of communication. Whilst there might be bad blood or bad feelings, be objective about the situation, give them a call. How can we resolve this without having to take litigation? Top tip for lawyers in the room and online, if you are sending a letter of demand, just be mindful of your obligations as a solicitor. Don't include any threatening or misleading information. That would be a breach of solicitors' conduct rules if you do. Don't demand payment of your legal costs for the drafting and provision of that document unless you've got a contract with that debtor for that to occur. Importantly, in terms of your client, don't take your client's word for it in terms of what the debt is. Don't just receive an email or a phone call from the client saying, I'm owed $50,000, what can you do about it? You want the contracts that give rise to that debt. You want all the information on the debt that the client has. You need this in your armoury in any event if you need to take proceedings, so have it first up. Know the situation firsthand. Don't rely on second-hand information from your client, even if you've got a long-standing relationship with the client. Do your due diligence at the front end. It'll serve you well throughout and at the back end if you need to go that far. Another sort of handy hint is timing. It's huge. Diarise your dates. If you're sending a letter of demand and you're giving them 7 days, diarise it and promptly follow it up. It shows that the debtor that you're onto things. It shows that the client that you're onto things. It's just good for your own processes and your procedures as a lawyer that you know you've followed things through in a timely matter and you've scheduled that. If there's no luck or no joy with regard letters of demand and or telephone calls to debtors, then you're in the court and you need to decide how you're going to recoup this debt. There's a number of ways, generally speaking. It can be commence proceedings, prove your debt, get a judgment and continue on enforcement steps, or you can enliven some of the statutory processes like Rod mentioned, the creditor statutory demand, the Corps Act if you're dealing with a company, or a bankruptcy notice if you're dealing with an individual. The benefits of starting a proceeding first is that whilst it's more time consuming than going to your statutory demand process first up, you get your claim laid out and assessed by a court, get a judgment. That's good for 12 years for enforcement. It might take you longer to get there and a bit more costly, but it gives you that full force and effect. It gives you something to really enforce. And there's no genuine dispute, because if there's been a genuine dispute, that's been ventilated through the court process. Once you've got your judgment, you can then make your application for winding up in the case of a company. The other alternative is a statutory demand process. Again, it's a statutory process, so it's very technical. You need to follow the forms and follow the rules in a legislation to a T. Again, the importance of time. You've got to issue a winding up proceeding within 3 months of the service and expiry of service of the creditor statutory demand, and if you don't, you're out of time and your application will fail. So you really need to diarise, you need to be on with timing, and you need to even keep your own checklists about things that you need to do and when you need to do it. Don't forget postage times, that applies to stat demands as well. I recently had a matter wherein a creditor statutory demand was served on a debtor by a creditor. We also had a client who was also seeking money from the same debtor. The other parties brought their application to wind up the company on the basis of the presumption of insolvency, which occurs after the 21st day of that statutory demand being served, and no response. They lodged their application, but they miscalculated the time. They were 1 day short, or 1 day late, I should say, in bringing their application for wind up on the basis of the postage. They hadn't calculated postage correctly, taking into account public holidays and weekends, because the rules are such that it's only working days that count, and then you add your postage to that. So timing is crucial. If you're ever in doubt, ring up a colleague, ring up a lawyer, ring one of us, we'll help you. The other sort of avenue in the insolvency space for individuals is a debt bankruptcy notice. Again, a very technical area. There's strict time limits, strict forms. Stick to those. If in doubt, ring up a lawyer, ring up a colleague. The winding up applications, the bankruptcy proceedings, there's different jurisdictions you can choose. Generally Supreme Court or Federal Court. I've done applications in both. There's a checklist generated by the court in each jurisdiction. Stick to the checklist. Stick to the checklist. Keep it on the inside of your file. I know we don't really have hard copy files anymore. We do electronic things these days. I still keep hard copy files because I'm that person. Physically check off your times, your dates, the things you need to do. A bit of a slight horror story there that I had in my younger years, a few years ago now. I was in the federal court on a wind-up. There was an adjournment application made. I'd filed all my documents, I'd filed my affidavits 7 days in advance, all those things. On the adjournment, on the return of the date, the adjourned date, I didn't file the second affidavit saying you need to have checked all the national personal insolvency indexes and all that kind of thing. I hadn't done that. I got an adjournment for a week and was able to do it, but it wasn't on the checklist in my defence. But again, re-enliven the checklist through adjournments and different things that might need to occur. What else? Abusive process. We can see and have seen the creditor's statutory demand process and the winding up process used for debt collection purposes rather than with an intention to actually wind up this company when a liquidator and to bind assets and get distribution to creditors. That's a big no-no. There's a lot of case law out there about that. We always make sure when we are giving advice to clients that they are steadfast in their approach with the use of these tools and that they're doing it for the purposes of, well, if I need to wind up, I will. Another sort of segment to this or element to this is your Office of Compromise and your settlement agreements and mediations and things. In that process of court, there will be a court-ordered mediation. There's also the opportunity to send Office of Compromise under the rules, look at the respective rules, whichever jurisdiction you're in, and send offers. A prior mentor of mine said to me, there's 3 circumstances in which you should send an offer of compromise. When you've got a good case, when you've got a bad case, just in any case. It is a mechanism you can use to try and promote discussion, to try and keep the pressure on the debtor, to try and massage the proceeding the way you want it to go. Even if it's not accepted, timing again works in your favour. The clock still ticks for the purposes of costs. So if you've made an offer of compromise under the rules, there's presumptions and provisions there that have a cost impact and a favourable cost impact on you if you later go on and you're successful in your claim. Colder banks again is another format of an offer. Mediations, my view about mediations, always do them. Any opportunity you have to do them, do them. There is no such thing as a bad mediation. You find out how good your case is, you find out how bad your case is. You find out if you can go all the way or if you really need to settle. And if anything, it keeps that communication open. I find mediations really useful, and I'm a big advocate of those in any proceeding. Nicole, hi.
As a mediator,
Yes.
I love what you've just said.
Thank you.
What's your perspective on mediating before you even issue proceedings?
Sure. Again, never a bad thing. In line with the picking up the telephone at the first point of contact, any way you can narrow issues in dispute, do it. It's a win for your client, it's a win for you. I had a situation where it was at that stage, letter of demand type stage. We sent a letter of demand, rang up, followed up, and just kept that communication going so early and so consistently that once we resolved the matter, that debtor actually rang us up and said, can you guys act for us? So you just don't know the power of a phone call and that human interaction. I've had other circumstances where I've rang up and they've said, oops, forgot to pay it. Life happens, we're all busy people, we've got family obligations, other obligations outside work, things get missed. Right.
Yeah, I love that point about communication. I think in the digital world we tend to avoid voice-to-voice communication. But the other point I had is, how do you know whether it's actually worth pursuing the case? They might have $1 in the bank, they might not have any assets before you even start that process. Because I've had people, it's just I'm going to shut them down as a revenge process rather than recovering money. So how do you answer all that?
Yep, so just for the people online, the question was how do you essentially know whether or not engaging in the process is going to be commercially worthwhile, whether there's going to be pot of gold at the end of the rainbow before you start off?
Yeah, it's a great question, and it's something that needs to be considered at the very early stages. Recoverability is huge in this area. You are not going to spend $5,000 to get back 500. And doing something for the principle of it, or because you've got an axe to grind, or because you're upset and the emotionality of it, doesn't feed your family, literally doesn't pay the bills. Assess at the early stages what the recoverability prospects are. Do as many searches as you can, title searches, property searches, PPSR searches. Find out as much as you can about the assets of the individual or the company to inform your decision about how far you take it.
Thank you.
Just circling back to one of the things you said before, Caroline, you mentioned that stat demands in particular aren't a debt recovery tool and shouldn't be used as one. That seems a bit odd because I think everyone here, whether it's in the room or online, would know what they are and have either issued them or told lawyers to issue them because this entity owes me money and so therefore issue the statutory demand. The court's pretty clear that it's not to be used for a debt recovery tool, but what happens if ultimately that process doesn't go wrong? What happens if, for example, the debtor applies to have that statutory demand set aside and they win?
Well, the big problem there you've got is costs. You will be facing an adverse cost order and that could be substantial. And then you're no further forward, you're actually further steps back. It's a bit of a disastrous situation to plough through with a statutory demand winding up and then someone applies, the debtor applies to set it aside because there's a genuine dispute. There's a problem with the stat demand technically. You will end up in a very worse situation. You've lost face with the client and the debtor and you're back to square one. It's just not a good idea. So try and avoid and find out as much as you can about the debtor and their assets and consider other avenues of debt collection. It might be just commence proceedings. Yes, it takes a little bit longer, but all these issues come to life very quickly and you can mediate through that process.
Just to add to that as well, my experience is that statutory demands can be, and bankruptcy notice, but statutory demands can be very good at getting a swift reaction, but at the same time it's not necessarily the best reaction. I've seen that there's case law out there where statutory demand was issued on the back of admissions from a debtor that they owed the money. So it was emails back and forth, yes, we owe the money, we will pay, didn't pay, it was in relation to the supply of widgets, whatever it was. And statutory demand was issued and the debtor applied to have it set aside on the basis that there was a genuine dispute. Now, how can that be a genuine dispute when you've got troves of emails saying that there is no dispute and we will pay? And the debtor in that case argued that at the time I sent those emails, there wasn't a dispute, but today there is. I found something wrong with it and there is a dispute. And the court said, well, you're right. This is not the forum to figure out whether or not you're right or wrong. The only issue I have to decide is whether or not this is a genuine dispute and the statutory demand was set aside and the creditor in that case had to start again. So they can be very powerful tools, but they can also come with some pretty severe consequences. So go down that path very cautiously, I think. Yeah. Any other questions for everyone?
I guess just to add on to that, the practice in good debt collection practices is not to actually issue a creditor's statutory demand unless there's a judgment behind it.
Isaac.
Yes.
Good morning. Now, we've commenced proceedings. We've gone down the safe path of commencing proceedings. We can't find these rogue debtors. What do we do?
Yes, that seems to be a question that comes up a lot during the debt recovery process, and there may be two things that we might suggest. One is skip tracing. This is where we get our private investigators to go out and hunt the debtor, pretty much try to locate where he is. The cost is about $400 and $500 depending on the case. They say they have about 91% success rate in locating the debtor. One of the good examples that I had personally with going through skip tracing is they were able to locate the debtor's girlfriend and they were able to pay the girlfriend a visit and able to locate where the debtor was. So it was a long process, but still it's effective in that way. If you're really, really looking for the debtor who owes you a lot of money, spending $400, $500 in skip tracing could potentially locate the debtor that you're looking for.
And if you do get charged with stalking, we do have a criminal
We don't actually go to their properties and knock on the doors. We just leave that to the private investigators to do it, so we're safe.
Okay.
Yeah. The next thing that we might suggest doing is substituted service application. You could do this when you have court proceedings or even bankruptcy notices. You could actually get substituted service orders from the court. This is where we tell the court that it's almost impossible to serve these documents on the debtor. So we propose to do so by other methods such as emails, prepaid post, or text messages, even social media. I think social media is a very interesting one because court registrars, who are younger court registrars, they really love social media methods. One of my successful stories about social media is we couldn't locate this debtor. He was a ghost. We did skip tracing. The report came back saying he's a ghost. We can't find anything about this guy. But he did have an Instagram, which he posted his last picture 2.5 years ago, which is not enough for us to actually go to the court to say, it will reasonably come to his attention. But I just had a feeling that he's gonna make a mistake, or I just wanted him to post something. And I kept checking every day. And in the Instagram page, you have that little circle thing on the profile. It's a story that they upload, which goes away after a certain number of hours. And I was so happy to see that. Clicked on it. It was him having a barbecue. It was the most depressing barbecue, so I don't know why he posted it. He posted it. I was very happy. I was able to screenshot it and then use that as evidence when I made the application to the court, which the judge or the registrar granted it, and we got the judgment against him, and he eventually paid the money. So it was very successful. It works. So yeah, question.
We've got a question online. When it comes to personal service of orders to a lot owner that are overseas, and the court is not accepting the substitute service, is there a way around it?
Ooh, I feel like
I've been holding on to this question for you.
I might jump in there as well. Service is difficult. There's all sorts of different rules for different courts. Here in Victoria, each of the Magistrates Court, County Court, Supreme Court have got different rules of service. New South Wales is a little more uniform, and they've got uniform rules. But there are certain difficulties with trying to serve someone that's overseas. So at some courts, I have been successful previously at getting substituted service orders by emailing someone that was overseas that we knew at the time. Other court rules specifically say that that's not possible, and so you need to then take steps to serve that person in that jurisdiction in the way in which that jurisdiction would allow service to be done. So I'm going to sit on the fence there and give a bit of a lawyer/politician's answer and say it depends, but there are options.
Thanks.
Just circling back to one of the things you mentioned before, Isaac, with substituted service. So
yes.
I suppose contact details for the debtor is important. That probably goes back to what Rod touched on before, the credit application and whatnot, which is getting as many details as you can.
Yeah. Yes, I think when clients come to us, we tell them, you are our best evidence. You need to give us as much information as possible. Yes, we could go through skip tracing and all those sorts of things, but we rather not spend that money, and hopefully you could give us as much information as possible. So without being too creepy to the people that you're dealing businesses with, I think it's important that you keep a lot of good information about them, contact details, recent contact details as well, and also keep a lot of paper trails. So just don't pick up the phone and talk to them, but make sure you once in a while exchange text messages or emails and things like that, which would be very useful when it comes to substitute service applications.
So, Captain Stalker, once you've actually found the person that's been avoiding you,
Yep.
hopefully they pay straight away. Sometimes they can't, and it's as distinct from being unwilling, but sometimes they can't because cash might be tight or whatever else. What are some of the things that we can do to try and help that along?
Yeah, I think Caroline mentioned earlier that it's very effective when sometimes you get on the phone and they just couldn't pay because they're dealing with life in general. But it seems like every time I talk to these debtors, they seem to have cancer or depression or all sorts of issues that it becomes very repetitive. I feel like, but what we try to do from the get-go is try to be very amicable in our approach. So we're not coming at them and saying, we demand you to pay this, or we're gonna take certain actions by the end of the day. We try to be very amicable, try to understand their story, and I think because of the experience that we have, we kind of get an idea of whether they're actually being genuine or they're not being genuine, just giving you some fake sob story to make it kind of go away for another month. So I think that's a real experience that we have, the know-hows that we have, and we're able to go back to the client and maybe suggest, they're dealing with this issue at the moment. How about we approach them more softly with certain approaches? So there are ways to deal with this, and I guess it depends on each case. Yeah.
So when they can't pay, as distinct from being unwilling to pay,
Yeah.
Most common thing that we see is a payment plan.
Yeah.
And sometimes people will say, I can pay you this, and then how about we have a chat later on? Now that might work. That's not really in agreement, but we like to try to lock people in. So it's a payment plan. What's a more formal, safe way for a creditor to lock in the debtor's obligation?
Yeah, so if we are able to reach an agreement with the debtor, that's great, but we actually want to put that in writing, make it legally enforceable as well, so that there's no dispute as to the amount owing. So we call that the deed of settlement or terms of settlement, basically capturing what the agreement was. So a settlement amount of $50,000 and payment plan to be paid in the next 6 installments. So we will capture that. In the event that the debtor defaults in any of the payments, then that gives us the right to run to the court and ask for a judgment for the balance of the debt owing. It's a very powerful tool to have, and we recommend everyone to actually tie up the debt recovery process with the deed of settlement or terms of settlement to make sure that that agreement is in place in writing. Yeah, so I think the deed is a really good way to do it.
What are some of the other clauses that might be helpful in those deeds to give some protection?
Yeah, so in the deed, I feel like some of the things that you could include is the default clauses. As I mentioned earlier, it gives you the right to run to the court and ask for the judgment. Maybe you want to include some charging clauses where possible. Take security wherever you can. Include all the parties. So if you're dealing with the company, make sure you want to get a guarantor as well, a natural person that you could come after, because it's so easy to put down the company and just run away from everything, being the director. So if you could get the director to provide guarantee, that's really good. And draft any ancillary documents that form part of the agreement. So if there is a court proceeding, and you might want to annex the consent orders at the end, basically saying once you pay the full amount, we'll file this with the court and have the proceeding dismissed rather than going back and forth. It just saves time, and it's a really good practice to have. And you want to capture everything about the issue with that when you're signing the deed, and you don't want to come back and worry about it later.
Any questions for Isaac?
Does anyone use the sheriff anymore to collect?
I think we do. We do. Yeah. We definitely put it as an option when client asks for enforcement actions. But I worked at the court as well and dealt with sheriffs, and they're nice people, but very, very slow. Given that there's so many, it's not efficient because there's so many
in the options that you've got.
There's so many matters that they have to deal with as well. There's a lot of backlog, and if warrant is the issue, you pay them a visit and they say, oh, this is actually not my house. and they don't really have a choice but to leave the premises. So you might have waited all that time for nothing. Yeah, that's my experience with the sheriffs.
Yeah, I agree
Yeah.
with that.
Question online.
What happens when you're dealing with someone who's self-representing? What are some of the expectations that you can have?
Settle.
Quickly.
Cause work.
Look, don't assume anything, I suppose, and take them at face value. But also, as a practitioner, you really should extend to them, sort of model litigant guidelines, and that is, without injuring your client, you extend to them courtesy, respect, and you can explain processes and procedures. You can't give them legal advice, obviously, but you can certainly deal with them in a realistic and practical manner. I have had experiences where I've dealt with self-represented litigants, and they've gone a number of ways. They can be a bit explosive, they can be a bit entertaining, or they can be quite reasonable to deal with. It's a bit of a mixed bag.
Would you expect time delays?
Yes, absolutely, I'd expect time delays. But I think you can massage that and you can talk to them about that, give them information about processes. And the court will, in terms of the court proceeding, if you're in that jurisdiction, the court will give them time limits to comply with. We'll help them along the way as well.
How are we placed for time?
Time for a few more questions.
More questions?
Can I just add a tip to Isaac's
Yep.
terms of settlement? Another thing you can add into your terms of settlement deed is just things like future cost protection. So if you're settled on a matter, you've got your charging clauses, all those things.
Yep.
Just build into your terms of settlement that if you need to go back to court to enforce the terms of settlement, the debtor pays for the cost of that. So it gives your client that insulation between, okay, I'm settling now, but what if I have to go back to court? How much more am I going to have to spend? Build that into the costs, the terms of settlement agreement, and you've got a bit more protection there as well.
Yep,
Do you
that's
agree
right.
with that?
Yeah, I agree with that 100%.
Yeah, a question on director's guarantee. So in a scenario where you as the supplier might be a large dominant player in the market, and you're entering into a creditor with a much smaller, say, sort of mum and dad business, are there issues from a duress, market abuse, unfair contract term in saying we won't supply to you unless we get personal guarantees?
No, it's not an issue. They can either take it or leave it, and that's where it sits.
Freedom of contract type arrangements.
Yes.
I've got a couple more from online. Is there a time limit on an enforceable court order?
Yes, there can be. It was 6 years, I think it's 12 now when you get to full judgment, it's 12 years.
12 years
Yeah.
in Victoria. Yeah.
Yes.
It's longer in other states.
Got another one for Isaac. How long does it take for a skip tracer to act? Sheriffs take so long.
They want to get paid as soon as possible, so they act really, really fast. I think skip tracing itself, I think I'll get a report within 2 weeks, but along the way, they would kind of keep me updated in terms of what they're doing, and if they find anything along the way, before they actually give me the comprehensive report, they will let me know, and they will actually ask me, we got a few addresses, do you want us to actually, before we continue on with their investigation, do you want us to try to serve them on these addresses first? Which sometimes I would say yes, and you could actually save a lot of money. You don't have to actually spend all $500 on it. Yep.
Whoa, yes.
Just following on from the director guarantee point, I know we've spoken a lot about enforcing against debtors. Just, I suppose, in your practice, at what stage do you start considering, pursuing these sort of director guarantees?
Want me to take that one?
If you like.
I think, as Rod said, if the debtor is, asset poor, is not going to have good recovery prospects, you would look at the guarantee. If you've settled part of the debt with the debtor, then you might look at the guarantee. It just depends on the nature of the case. It depends on a number of circumstances. So the politician's answer is my answer to that.
We have another one somewhere. Yes, again.
I've got another one. What happens if you're handling a bankruptcy matter that ties in with a deceased estate?
So, for all of my sins as a lawyer and a litigation lawyer and insolvency lawyer, to sort of paraphrase from The Sixth Sense, I bankrupt dead people. So you can actually bankrupt a deceased estate, and the advantage with doing that is you don't actually need to get a judgment before you go down that process. It's a bit more streamlined. Why would you do it? I remember being in an aged care, I'll give you a speech to an aged care bunch of professionals, and mentioned this as a possibility of recovering some of their unpaid debts. You could sort of feel the life suck out of the room. That's probably the wrong turn of phrase there, but it sounds horrible, right? It's like bankruptcy in itself is awful, and bankrupting a deceased or a dead person is horrible too, but can actually have really good advantages, because often we see people either deliberately try to shift assets from one to the next, and or alternatively, it could be the next stage, which is even worse, where some people who are acting under power of attorney or some other nefarious means can take a property or take assets from someone and take it away, and then when they die, if there is no money left in the estate, there's no reason to obtain probate, there's no assets to recover. If you proceed down the bankruptcy route though, a bankruptcy trustee has a number of different claims that they can make to effectively overturn transactions, recover monies that have come back. So it sounds really, really awful. It can be very effective. I've had two recently, this calendar year, for example, where there was a recovery for the petitioning creditor in full with their costs and ultimately an annulment of the estate by virtue of all the debts, including the trustee's costs being paid out. So it does sound awful, and I probably made it sound even more awful, but it can be very effective.
I had a question, Rob. People in the room are probably pretty familiar with the idea of fixed and floating charges. It's what we used to see a lot of. I wonder whether you could just talk a bit about what that kind of looks like now in the context of the PPSR.
Well, they don't use the terminology fixed and floating anymore, but floating is circulating. What's the term? It's gone out of my head. The principles are still the same, it's just a different name. So you've got circulating assets under the PPSR, and they're still the same as what floating assets were previously under the old legislation. And fixed is still the same.
I guess, sorry, Brad, I was wondering a little bit about, we might have previously had in credit applications, provision for you can get a fixed and floating charge, but now is it the case that we'd include provisions around the PPSR?
Yes, you can do that, and you can identify that in your contracts if you want to. Not many people do, but you can.
Yes.
Just going back to your comment, Paul's one about bankrupting an estate. Where do you think the executor stands in that? And there's the involved in the estate planning and chartered accountant. I'm just wondering whether the choice of the executor is important in a defensive strategy here, where if the executor is also a beneficiary, you probably have success in claiming those assets back. But if the executor is an independent person, a trustee company, or me as their accountant, not involved in distributing the assets and not aware of that liability, I just wonder how that process would come back and how it would work.
Look, I suppose it depends. Executors have different roles and different powers than what a trustee in bankruptcy does, so that's the first point. Interestingly enough, a bankrupt can actually be an executor of a deceased estate, which sounds odd, but they can be. Without sort of starting off anew, given the time, a bankrupt can be a beneficiary to a deceased estate as well, but that beneficial interest passed to the bankrupt estate as well, so it's a pretty complex and convoluted way. My experience is that typically if you're going to bankrupt a deceased estate, you're generally not doing it where probate has been granted, because generally there's no assets there. If there is, usually a creditor would sit back and allow that process to happen. And in fact, it may even be a reason for the court to refuse a sequestration order by saying, there's an estate here, there's assets, this is unusual, let's just allow that process to pan out first.
So you're saying it doesn't work where probate's been granted, which is usually granted fairly soon after death these days?
Yeah, not that it won't be, but it could be. It could be a reason for the court to not want to entertain it. All right, well, I'm getting the wind up. Lastly, hot tips, Rod, fire.
Always ensure you have a clear credit policy and that everyone in the organisation knows what it is.
Communication is my hot tip. At the first instance and throughout, keep that line of communication open, gives opportunity to settle, it can narrow issues and disputes, and it lets everybody know you're on top of it.
Yeah. As I said before, try to get as much information about the debtor before when you're engaging business with them. The other one.
And mine is you catch more flies with honey than you do with vinegar. So, unless there's anything else, thank you very much for coming, everybody. Really appreciate your time, especially so early in the morning. Any questions, please reach out to any of us here or anyone else through the website. Otherwise, thank you very much for your time. Have a lovely day and all the best.